We're in the Judiciary Committee on this last day of February, Tuesday, and today we're going to start by getting some testimony regarding some of the budget requests in the General's Office, State's Attorneys, and Victim Services, so that we can weigh in on the budget requests with the Appropriations Committee. So we are honored to have the Defender General here today. Thank you for being here the first time this new biennium.
Thank you for having me.
By yourself for the record and proceed.
Sure. I'm Matt Valerio. I'm Defender General for the state of Vermont. I was told I was to give you a little bit of an overview of the system, and I'm going to keep it briefer than I normally would, given that we have important stuff to substantively to talk about, and I have, as we all do, limited time. Defender General's office is unique in Vermont for a governor's appointed position. The Defender General is appointed to a 4-year term and is confirmed by the Senate, but once you're appointed and confirmed, you're independent and there's no mechanism to remove you short of being disbarred. So you have to be a lawyer to be Defender General. Unlike I'm not saying that other people are unqualified, but unlike other appointed positions, the Defender General's office has a statutory qualification requirement that you've practiced law for 10 years and that you, in the prior 5 years before being appointed, the majority of the work that you've done had been in criminal defense work. And I've been Defender General for almost 23 years. I've been I was first appointed by Howard Dean, and then Jim Douglas twice, and then Peter Shumlin a couple of times, and now Phil Scott a couple of times. And one of the things I've found over the years, whether it is the right thing or not, I'm not sure, is that when I took over the DG's office, it had a long history of being in the red. It would routinely do things like stop taking cases. It would stop paying its contractors, stop paying its ad hoc bills. I was never a public defender before I became Defender General. I had background I was in private practice. I owned some other businesses and the like, and did a lot of criminal defense work. And in the probably 5 to 10 years before I became DG, particularly the last 7 years, I did a lot of DUI cases like everybody who does criminal defense. But my other part is I did a lot of murder cases and sexual assault cases. So that the side, and over the course of time, I also did juvenile cases more earlier in my career than I did during the last 7 years in private practice. But one of the things I had noted when I became DG, and I did some research in advance of becoming Defender General, I actually didn't apply for the job. But at some point, Governor Dean decided he wanted me to take it and convinced me that the DG had a structural problem at the time. And the structural problem was it had a huge reliance on ad hoc assignment of counsel and the staff system. So this gets me to the structure of the DG's office. DG's office has central office here, which has administration in it, and has the Prisoners' Rights Office, has an appellate division, has a juvenile defender's office, and then we administer all of the public defense offices in the entire state. So there's one in every county, except for Grand Isle, which Grand Isle is shared by Franklin, the Franklin office, and that is a staff state employee public defense office. The way the statute is set up, and I'm talking about now the primary public defense side, it allows for private contracts to provide primary public defense services in certain counties, And it didn't designate which counties, but historically it developed where, for example, Washington County here, a private law firm, Richard Rubin's office has been the public defender, primary public defender for juvenile and criminal work really since the very beginning. This, by the way, is the 50th anniversary of the public defense system in Vermont. And that contract goes back that far. The west part of the state, primarily Franklin, Chittenden, Addison, Rutland, Bennington, they're all staff offices, state employees. The Wyndham office is the same way, but you go up the east side of the state and you hit Windsor and Orange. Those are contract offices. The entire Northeast Kingdom is contract offices. The Addison office is kind of split where the criminal part is staff and the juvenile is under contract. The one-person Lamoille office, it's actually 2 lawyers now, is a staff office. So we have a mix in primary public defense of state contracts and staff offices. Where things got interesting is on what I call the other side of the program, where there's a conflict of interest with the primary public defense office, whether it be staff or contract. And then you have your conflict contract side of the system. We call it assigned counsel. So in some paperwork, if you go onto our website and you want to look at our budget document, you'll see assigned counsel versus public defense. Public defense is the primary, assigned counsel is the conflict side. The conflict side now, however, represents about 45% of the total caseload. And so it's just as substantial really as the other side. Those contracts are layered, so to speak, so that, for example, in Washington County, here in Montpelier, Barry, if 5 co-defendants are arrested involved in a burglary, one of them will get the primary public defense contractor in Rubin's office, and then the conflict side, each one has to have their own lawyer, and we have layers of contractors in place to absorb that caseload. Part of the biggest problem that we deal with right now on the conflict side is not having enough lawyers where we need them to actually do the work. They don't exist, okay? And this is why when I talk to people about this, we actually don't pay them badly either. For example, we pay them $150,000 per lawyer equivalent caseload. What that means is a lawyer equivalent caseload is an American Bar Association standard that is set to determine what the average public defender working 40 hours a week, which, by the way, I don't know any average public defender who works 40 hours a week, but if there were one who did that, how many added cases they're supposed to be able to handle. And that standard is 400 added misdemeanors a year, or 150 added felonies, or 200 added other cases, which usually mean juvenile and probation violations or some post-conviction matters. I separate homicides out from that group, and I've created, one of the first things I did as Defender General is I restructured this program that was relying on the last tier, what I call the last tier of public defense, ad hoc. And that's where you've gone through all your contractors, primary, and all of the conflict ones, and now you've got cases left over, and they would all go to ad hoc counsel, who would bill at the time, and even now, $50 an hour to handle those cases. That was far and away the most expensive way we did business. And so the first thing I had to do as DG in 2001 was take my predecessor's request for budget adjustment, which was $700,000 on a $6.7 million budget, which is over 10%. I came over, and all of that was to go to pay for ad hoc bills. And at the time, ad hoc was in 2001 was about $1.2 million. the first thing I did is I zero line itemed ad hoc. And I took all of the $1.2 billion and I put it into the contract side. And on the contract side at the time, they were making $25,000 per lawyer equivalent caseload. And I doubled that to $50,000 to make it more palatable. And then the math, I made a bet with our budget person, Laura Evans, who you maybe have seen around here. She tried to retire, but it didn't work out. And she's been here, this is like her 50th year, seriously. So I made her a bet that we'd reduce ad hoc by 75%. And I was wrong. It was more than, it was actually 80% that we reduced ad hoc. Since that time, the Defender General's office has been within budget, without budget adjustment for 23 consecutive budgets. Now, the reason for that is what this contract side of the system does is allows you to know exactly what you're going to pay every year for the caseload that you have. There was also some little mathematical trickery there. I developed an algorithm that to attempt to predict caseload based upon historical average and a rise analysis. So where the little dots cross on the axis, that's where we're guessing the caseload is going to be in a given county. It doesn't always work, but it works, 80% of the time. And so we were able to kind of predict ahead of time where the caseload was going to go and pay people appropriately. So over time, we were able to raise those payments per LEC from $25,000 when I first started to $150,000 now. And one of the other things we noticed is that a lot of the homicides and serious sex cases, which is what I would help the DG out with, were going to ad hoc counsel, and it was very expensive. And I knew that from personal experience. So I created these serious felony units that primarily focus on homicides, and they will take the occasional very complex or egregious sex case, or if there's a multi-level conspiracy case or something that's very technical, they would deal those. And what I was trying to do is to make it worthwhile for the best and the brightest criminal defense lawyers around the state to take those cases on. But they would say, all right, at the time we set them up to get paid $100,000 a year to have these contracts, which at the time was unheard of. It was, 3 times, well, actually it was 4 times what I was originally came in at, 4 times what anybody else was making annually. Ultimately, it ended up being twice as much, and they've grown a little bit over time, but they actually haven't kept up with the rest of them. So what all of this did was take this caseload that was unpredictable, because ad hoc, you never know what you're going to get for ad hoc. You also can't control who's doing the ad hoc, because the court just picks the next warm body in the courthouse. And you had people who were not qualified to do the work getting the cases. Courts, like anybody else, like the path of least resistance. So if you have a lawyer who's willing to settle every case that goes in front of them, you're going to pick lawyers who help make that happen, and things move along quickly and things are easy. Well, I guarantee you that the serious felony units do not make things easy on anybody. You have read probably in the last year a number of acquittals in homicide cases and in sex cases and the like. That's the serious felony units at work. And so that restructuring put us in a position where we can predict our budget, and if we can predict our budget, we can stay within it. Now kind of fast forward to today, our budget is now approximately $23 million. The payments are $150,000 per LEC for the contractors.
Sorry? Can you say that one more time?
$150,000 per LEC for the contractors. The system has stabilized from a financial standpoint for a long period of time. The things we're running into now, however, have very little to do with money and have a lot to do with our current job market. The job market for attorneys in the state of Vermont, where we get attorneys from, whether we get any attorneys at all. Those are all big issues. Vermont Law School provides almost no lawyers to the state of Vermont. When I was first DG, they had classes starting at about 275 people, and you might get between 50 and 100 of them staying in the state of Vermont to become licensed attorneys. Now their classes start at about 125, they graduate about 100, 85% of them never seek to have admission in the Vermont bar. Of the 15 people who take the bar attempting to get into Vermont, less than half of them pass. VLS is on probation with the ABA for its accreditation, and as a result, we try to split up there are about 7 people who stay in the state of Vermont every year who try to become Vermont lawyers, or who end up getting passing the bar to become Vermont lawyers. That's not a significant way to do, I can't even, I might be able to tell you, I did just hire one who came from VLS, but literally I can pick them out like that. You might see Carrie Johnston around every now and then. She was number 1 in her VLS class. I hired her 7 years ago or so, but in between the one I just hired and that one, I can't really remember if there were any. I don't think there were. So the way we're getting lawyers to come into the state of Vermont are different than the way we used to. It is people who have 4, 5, 6 years experience. They're coming to Vermont to be lawyers for various reasons. Spouses move here. They're looking for work, that kind of thing. But it's not the traditional group that becomes public defenders. And so it's very difficult to recruit. When I was first DG, if I had an opening in Chittenden County, I would get 120 resumes for one position. I had 3 openings up there in Chittenden County over the last couple of years. There were times I go 10 months without an applicant. We get one every now and then. If I get out of the Burlington-Montpelier corridor, and I went 18 months in Rutland trying to hire somebody, didn't even get applicants. I would get applicants who were not licensed. I would get applicants who were, suspended in other jurisdictions. I would get, people who were looking for their, they're on the edge looking for their next job. So we made an effort to go down to Boston, go down to New York, and attempt to go to those kind of law school fair type things for job fairs, see what we could do. We have not been particularly successful at that. We did end up hiring one guy out of Northeastern that has a public defense oriented program just to produce public defenders. But let me tell you what we're up against. I have a niece who grew up here in Vermont, went to Vermont High School, graduated from Proctor High School. Remember when you used to represent them?
I used to.
Yeah.
It used to be my constituent.
Yeah. Don't listen to us anymore, but you moved over. In any event, she went to a good college. She went to Holy Cross. Wasn't number 1 in her class or anything, but she was in the top 3rd. Went to Catholic University Law School. Again, was a good student there, but not like top 10 or something. She was top 3rd. And she got a job by a medium-sized firm in Boston, about 400 lawyers. It wasn't like Hale and Dorr with, 10,000 lawyers or, international practice or anything like that. A 400 lawyer firm in Vermont would be like 4 times the size of the biggest one we have. But down there, it's kind of medium-sized. And to start, she hadn't practiced a day. She just got this job in the fall. And I asked her about it because I am her uncle and she has to answer me. They paid her $200,000 a year to start. She has not practiced 1 day of law in her entire life. They said, if you stay 6 months, we'll give you 40 grand as a signing bonus. If you make your hours for the end of the year, you'll get an additional bonus. and we'll give you 10 grand to move. So her first year practicing law, she anticipates having cash coming into her from the firm of about $300,000. An entry-level public defender in Vermont makes about 60 grand.
So can, using that as a jumping off point for some questions as well, is that reflected now in the budget as far as trying to increase that or have bonuses, or how's the budget actually, the request that you have seeking to address the recruitment issue, and how can we help with that?
Well, one of the things that I've done is I don't hire anybody at entry level. It's not possible. So, we have a 15-step pay plan that starts at about 60, and at the 15th step, you're at like 122. But I have to really hire people in the 70s to even, get them to take a whiff. And so I've just been doing that, and I haven't had any kickback from HR or administration or anything about that, because they understand they're in the same boat. The other thing that we have done is we were seeing the same thing that the labor market is doing across the entire system. So we have reclassified a whole bunch of our positions to different higher paying positions. It has not been that effective, to be perfectly honest, but it's better than it was. So this year, the governor's recommended budget gave us about $1 million increase, and that $1 million primarily goes to salary and benefit increases and the reclassification of positions that occurred during the last year. What kind of got left off that's really pretty much it. We also, in the contracts that I do, because I like predictability with the primary public defense contractors and stability, at the beginning of every term, I enter into 4-year contracts with them, which is they match my term. And so there's an escalator in it. So, usually they don't rise more than 5% over 4 years. That's kind of been my pattern. We've had to increase those some, but those were all negotiated. I signed them, administration signed off, and that's also part of the sort of non-negotiable increases that are part of the $1 million that was in the governor's recommend.
Barbara has a question on that.
So I'm a little confused because I've heard from a few people who had asked for us to advocate for the assigned counsel rate to go up. And the assigned counsel rate, somebody was saying, is $50 an hour. So
that's not the assigned counsel rate, that's the ad hoc rate.
Okay. They said that the last time that was increased was in 1993.
That's correct.
And that by comparison, assigned counsel, as opposed to under the Criminal Justice Act,
ad hoc
was increased to $164 per hour under the U.S. courts.
Well, you're talking about apples and oranges and all kinds of things.
For attorneys who were concerned about
they're right.
taking the job for $50 an hour.
They're right. By the way, nobody takes those to make any money. So
are you apparently New Hampshire pays $125 and
thought it was $100, but that's all right. $125 for serious felonies and $100 for non-serious felonies.
Does this budget include increasing those?
No.
It's still going to say $50 an hour?
Well, there's a process to raise it, and it doesn't start with the Defender General's office. It starts with the court. The court has Administrative Order 6, and the court sets the rate. And the governor's recommended. You understand there's politics involved here? Right. The governor's recommended budget did not include this increase, and the Supreme Court had not authorized an increase under Administrative Order 6. So the Vermont Bar Association has requested that the Supreme Court increase the rate from $50 to $100. That's perfectly, from my perspective, that's perfectly fair and acceptable. The legislature then has to decide whether or not it wants to fund that. That was not part of the governor's recommend, and the legislature didn't have anything to act on because Administrative Order number 6 hadn't been amended. So, I know that I know, number one, that the VBA has made that request. Number two, I know that the executive director, Bob Palini, and the president of the VBA are meeting with the court, I believe, on March 10th to discuss that, or that's one of the things they're going to discuss. And so the process has been going on. Now, that process actually sort of started 3 years ago, but then we had this thing that kind of threw us all off. The pandemic basically put everything into stasis, and nothing was happening. We had cases trickling in and not very many trickling out. So everything just kind of stopped. But that process had sort of begun a few years ago. It's restarted. It has restarted now. It kind of started some number of months ago. You got to get all your ducks in a line. The VBA Board of Managers had to vote. Then the Bar Association can go to the court. The court then decides to do whatever it's going to do. Let me just finish one part about this. Ad hoc, even at $50 an hour, is the most expensive way that the Defender General provides public defense services. The ad hoc rate relative to our budget and the ad hoc expenditures is teeny tiny. It's $350,000 a year for maybe $400,000 on occasion. So we dropped it from years ago, 1.2 million. Now the big part of the program is the contracts. So it's like less than 10% of the caseload, maybe even less than that when you kind of figure out what, you have cases with counts. If you say the number of people, it's probably less than 5% of the people involved with the DG's office as defendants is represented by ad hoc. So it's important that we make that fair. But it's, like they say, bug dust in a $23 million budget. It's not the money.
Okay, so my understanding from approach, and we've got to get recommendations to them, so that's why I'm going to try to focus you on this. But so you're requesting 1.9 million in new positions?
No, not new positions. There's upward pressures that were
so some
our original ask of the governor was 1.982,962. That was our ask. The governor's recommend was 1,070,938, which left an unmet need of approximately $1 million.
And the breakdown that I have of that from Trevor is Central Office Administrative Services Coordinator. So is it reinstating that position for 84,769? And then
here, let me just give you this, and then you can have a whole list, and it tells you exactly what the unmet need is. I might even have another one to look at.
Right. Okay. And
in order, the most important, and I was going to get to this, but the most important thing that we can't control, that we haven't been, has been eating away at our budget, is other personal services. When you have a case, you need to hire psychiatrists, psychologists, investigators, transcriptionists, ballistics people, crime scene reconstruction people, all of the litigation support people. And a lot of it is doctors. A lot of it is psychologists, competency evaluations, mitigation specialists for mental health purposes, and the like. And that line item in our budget hadn't been raised in 8 years. And I had asked for $400,000 on public defense. You'll see this on the sheet I just gave you. It's the top line. And $100,000 in other personal services for what we call assigned counsel, which is the conflict side of the program. All right. And
So is conflict part of the other personnel services?
yeah, well, you have ops on both sides. You have public defense ops and you have assigned counsel conflict ops. So the bigger expenditures tend to be on the public defense side. So I'd split it up. But at the end of the year, if I need to, when all is said and done, we're closing out the fiscal year, I can then do like a transfer and, the money we have left will pay off whatever we need on the other side, that kind of thing. Usually what it is public defense paying off assigned counsel, as opposed to the other way around. But all of that having been said, that $500,000 is the biggest piece of the unmet need of about $1 million. The other things that are on that list include restoration and funding for in-person training, 26.5. During the pandemic, we couldn't have in-person training, so when I was doing budgeting, we got rid of it. I asked for it to be put back in because now we get together again, but they didn't put it in. So it's an unfunded need, all right? Out-of-state travel, our Prisoners' Rights Office, as you probably know, travels to Mississippi to check on our inmates who we have down there. And that trip is usually made 3 to 4 times a year. We were not doing that during the pandemic. Put that money back in. The central office administrative service coordinator, I actually just had a meeting with, there are a lot of ways to go around doing these things. I had asked first with the administration to put one in, and this is my biggest current concern of anything that we're dealing with. It doesn't necessarily have to do with money. Our system in 1972, 73, when it started, had effectively administrative services manager, a financial specialist who the administrative services did the budget and things like leases and that kind of stuff. We have a financial specialist who pays the bills and an HR person. In the last year, all 3 of those people have left or retired. I hired somebody to replace Laura Evans, who was our administrative services manager. That person stayed 1 year and quit. Laura Evans is now back. That's why she's working on year 50. The person who paid the bills, our financial services manager, had been with us over 30 years, 35 years. She retired, hired somebody to fill that job. That person unfortunately got cancer and is out indefinitely, and we don't know if she'll ever return. The person who did HR, we have a new case management system going in, given that our prior one was no longer being supported by the vendor. We'll go live July 1st. We have the funding, we're fine with that. But the person who was our HR person became the project manager for that, has been working on that for the last 3 years. And that will be the last thing she does for the Defender General's office, because when she's done with that, she's gone from her HR job. She retires, and she's been here over 30 years. I always say, when the DG's office, when everybody is where they are supposed to be, we can get by just barely. When one of them leaves or whatever, it's chaos. And we had all three of them leave. The person who does the budget, manages all of the leases, cars, and things like that, gone. The person who pays all the bills, gone. The person who pays all the employees, gone. And all this, of course, you know what happened during the pandemic. Everybody left. And when, frankly, the treasurer, the legislature, the administration was diddling around with the pension issues, all those people who were hanging around who said, now we're getting out while the getting's good before they change my benefits. So they retired. It caused a problem.
I apologize. I know that we only have you until like 6 more minutes or.
So I just all I got to do is be able to get to Capitol Plaza by 2:00. So I'll go till I got another 15 if I need to.
Okay. So I guess a couple things that we need from you.
That administrative services part, by the way, is to add a person in so that we develop a bench so that when one person is out, we have somebody who's cross-trained to do the other jobs, which all those other three used to be, but they're all gone. So now nobody is.
So now this is all really important for us to know, but I want to go to a little higher level because we're going to weigh in and say, this is why, from a policy perspective, granting these additional requests from Defender Generals is critical. And I do have one specific question, which is how much of this has to do with court reopening, particularly if state's attorneys are trying to bring on more people. The court is trying to bring on an additional judge and such. So that's the more specific question. But the other is, can you give us, help us with the policy reasons from your perspective of what we, for us to be advocating on Defender General's behalf? I mean, I could make it up and stuff, and I'd rather hear it from you.
Well, the first question is an easy answer. None of this has to do with the court reopening. I have ARPA money that has been converted to general fund that we are using to address specifically the court reopening. So I've put into place additional contracts that are caseload relief contracts to absorb caseload across the state, some of which are roving statewide, some of which are assigned to particular high volume counties. And that is addressed in effectively carry forward from a couple $1 billion in ARPA money, hoping that we're going to try to get out of this within the next couple of years. I figure we'll run out of that money somewhere in probably by the end of fiscal year 25. So none of this has to do with that.
Okay.
I am concerned if the court or the prosecutors end up with a significantly higher ability to push cases through the system, what our ability to respond to that is. However, if there aren't a lot more judges, it doesn't matter how many lawyers you have because you can only stick so many cases through one judge. And I hear the courts asking for like one judge, and that's not going to make any difference for anything.
So if they were, so one of the metrics we were looking at with Terry Kersowens is throughput. And then she was talking about how they're trying to get to 100% and such. And I guess a question for you is if they were to set a goal of 125%, because we really need to get rid of the backlog, does that connect to what your asks are in some direct manner?
It doesn't connect necessarily to the asks, but it connects to the whole budget as, when you think about the carry forward of the other money. I think I've got the people in place right now to handle that. I know what Terry's talking about. I also have seen the court's closure rate for the last couple of months. They had like one county that was over 100% and everybody else was losing ground. So, I'm not too worried about 125% at this point.
Well, Yeah, no, although we're,
Yeah, I'm just talking about reality.
right, exactly. And but we're, from our perspective, are pushing, the various parties, the stakeholders, defenders, the state's attorneys and the courts to get up to some number that's above 100%.
Yeah.
And
I think we can do that now. We got people who are sitting on cases who can't get court time. We got cases that are old that people want to have trials, and I've got people assigned to them ready to do trials or ready to do litigation as necessary.
you're ready to go.
So we're ready to go. And the thing that's kind of interesting about it is that in other times when you have backlogs, it's because of massive volume coming in and that kind of thing. We're just kind of getting back to normal right now. And the volume that the cases that we have that are ready to go to trial, they do settle, but we have a lot more that actually need trial. Like, we've gotten rid of the low-hanging fruit at this point. The ones that could be settled easily or the like. Now, we might get right up to trial, and then they settle. But that's what you need. That's what you need to do, because the prosecutors are in the same boat. Prosecutors have had a rough time, and it's not their fault. It's been 3 years. They don't know where their witnesses are. They don't know where, the evidence is dried up. They can't prove those cases. And so the resolution of the cases becomes a lot quicker and easier. Either it's by dismissal or diversion, deferred sentences, or deals that you wouldn't otherwise get because the evidence isn't there anymore. And on our side, I'll tell you honestly too, I'm guessing that anywhere from 1/3 to 40% of our clients, we have no idea where they are.
So is the argument for supporting the budget request, I mean, this is going to sound very simplistic, but I'll throw it out there and let you bat it around a little bit. Is it essentially the due process for criminal defendants, or is there more?
This is to keep the system intact, in my view. This is to keep it intact as it is.
And we want our system of defender generals to be intact.
I would hope.
But because from your...
It's a constitutional violation if the people are ineffectively represented.
Right. I just wanted to hear it from you, not from me saying that.
Yeah, no, I mean...
That's what we need to be arguing, is that we need to keep our defender general's office intact because there's a constitutional right to effective counsel.
And every single thing in this that really doesn't add anything to our system, all it does is keep it so that we can keep what we had in place based on current market conditions. 4 years ago, the psychiatrists were charging us $175 an hour to do evaluations of people, and now they're charging $300. All right. So that's a market thing. That's not something the DG can control. I know that it's just, everybody who works now, if you haven't noticed, is making much more money, and they can demand it and they can get it.
Huh. Right.
That's.
Unless you're legislating.
Well, I have, unfortunately, sometimes I have to have this conversation with some of the people who come and say, well, some of the investigators have come and said, well, we're making $40 an hour. We want more money. I said, well, the lawyers who are doing the ad hoc work are making $50 an hour, and I'm not going to pay you more than I'm paying the lawyers. They said, well, it's not enough money. I said, well, then don't do the work. Make your choices. We'll work on it. We'll get you where you need to go. You got to be patient, but you've got business decisions to make. I understand it. Well, some walk, some don't. It's just business. It's all right.
I do. So I know our approps rep or contact said that they were asking you to prioritize, and I don't know if you want to share. You did.
That's the priority. The priority is right there in front of you.
In order.
In order.
Okay, so if you got half of it, you'd go down the list.
Yeah, you got to think of it as two sides of a program. So public defense, top to bottom, those are the most important things. Assigned counsel, there's not really that many of them. There's only two, and top to bottom. One way or another, I'm going to figure out a way to raise those serious felony units to 150,000. somebody else, I'll eliminate a contract somewhere, I'll do something, but I can't, they are very, very important to everything, that goes on at that high level of practice. And we aren't going to be able to keep them if we keep them where they are, because everybody else is making 150,000 per lawyer equivalent caseload. I control those serious felony unit caseloads and personally assign and allocate to them. So even if I look at them as being $200,000 a year jobs, I will make sure that they are doing like 3/4.
And so one more question. You answered the question about judges.
Yeah.
If the state attorneys are successful in getting some or all of their requests, how does that affect you, and what do we need to know about that?
Well, I am aware of their request. It kind of made me chuckle, to be honest. But they can ask for whatever they want. Again, you can only try one case at a time. So you could have 1,000 state's attorneys. If you only have one judge, it doesn't matter how many they have. And I've got lawyers who, they're loaded up with cases ready to go now. But if you can only try one at a time, it doesn't matter if there's 1,000 lawyers on the other side or 100. I think it's a little crazy to give them the 1,000 lawyers or whatever it is they're asking for. But I don't think it, as a matter of actual management of caseload, I don't think it'll make any difference at all from our side.
That's what we needed to. Yeah, that's I think.
So I think that's gives us what we need for our role in this whole process.
Yeah.
Really appreciate you coming in, and we'll look forward to seeing a lot more of you after crossover.
Right. Well, thanks for having me. And if you have any questions outside of the room, my office is just over there. Just call me and I'll answer your email me, do whatever you like. Sorry I couldn't take more time, but you might be happy to know that I've got to meet and try to resolve some things with Commissioner Demmel, who, by the way, I do think is doing an outstanding job, and I wouldn't trade places with him.
Good luck with
Corrections, right?
Should I just copy hers?
it. We'll get it loaded up on
Yeah,
online. Yeah.
And I do have, that's.
Do you have other things you want us to put up on our?
No, nope.
Yes, we do have this already.
I think that Representative Squirrel
Yeah, that's what.
had it.
Yeah, and I sent it.
This person or the other one from Trevor?
Well, the one from Trevor has that in it, but
Thank you. Good to meet you all.
we can get that to you.
Thank you.
Nina,
It's
too.
okay to see the rest of you.
I'll see you around.
Yeah, I'm sure.
Thanks a lot, Matt.
Thank you, Matt.
Thank you.
All right, we are going to now hear from Annie Noonan, who I believe is online, or hopefully still online. There we are.
Thank you, Mr.
Yeah,
Chairman.
If you could identify yourself for the record and proceed, happy to have you here today. Thanks.
Thank you. For the record, my name is Annie Noonan. I'm the Director of Labor Relations and Operations for the Department of State's Attorneys and Sheriffs. Thank you for allowing me to testify remotely. I have just been getting over a pretty significant head and chest cold, and I thought to myself, I didn't really need to bring any more germs into the State House than what you guys are already dealing with. So thank you.
That.
Yes, I'm sure you do. Okay, so following sort of the way Defender General Valerio laid it out, we have 4 budgets under our department. We have the state's attorneys, the sheriffs, the victim advocates, and the special investigation unit. Very briefly, we have 135 employees in the state's attorneys, 40 in the sheriffs, 27 victim advocates, and we have 1 contract employee with the SIUs who is basically the grant administrator. So that you know, our staff in both the state's attorney's offices and with the sheriffs are unionized under VSEA. So we have been bargaining collectively with the state's attorneys since 2020. We are on our 2nd contract with the state's attorneys staff, and we are going into this Thursday, our first contract negotiations with the state transport deputies as part of the sheriff's division. We have 28 constitutionally elected positions, officials, the state's attorneys and the sheriffs. I'll try to go through the budgets very briefly. And I do have a document that I'll ask if we can pull up on the screen. But first, let me just go through with you a little bit of what I think you've heard from Matt about what there's some of the challenges that the Defender General's office is facing. And I could just say, to go quickly through that, ditto. All of the expenses that Matt mentioned to you with regard to expert witnesses and the doctors, the psychiatrists, the transcriptions, all of that, we are in this exact same situation. We came out of the pandemic, and I think things have exploded in terms of costs, particularly around the doctors and psychiatrists. Some of that is being fueled by the contract that I think is being has gone with DMH. I'm sorry, with Dartmouth Hitchcock Medical Center, that has a lot of the psychiatrists at the state and other, not just us, but other state entities have used, and they've contracted out to some group in California to manage that. And Matt mentioned that the prices have gone from 150 to 300. And I'm actually here to tell you, I've seen prices on some of those where they've tried to get $600 an hour from us, and we've been fighting back on that. So it's, but Matt is correct. All of the expenses that the DG has seen, we have also seen. Our budget went up approximately between the proposed under the governor's recommend goes up about $1 million. And the vast majority of that money is in salaries and benefits for the staff. And things like fee for space and general liability, all of those costs, which we don't control. We just get sent a bill from ADS or from BGS and whatever. So most of the money that we received is going to be just paying for those increased costs. Our budget challenges, yes, I would correct one thing that the Defender General just said. We have not asked for 1,000 positions. We have not asked for 1,000 lawyers. What we have asked for is one position each we have basically three job titles in our state's attorney's offices: deputy state's attorneys, victim advocates, and administrative support staff. And we have asked for one additional position each in all of those three titles. So one additional deputy, one additional admin, and one additional victim advocate. You might say, if you, I guess my response to Matt would be when he says, well, nothing can get through if you don't have the judges. Well, we are currently, our deputy state's attorneys currently handle between 400 and 450 cases. Our victim advocates have 700 or more cases. And our administrative support staff, in many of the offices, we have one, sometimes two admin support staff. After the Odyssey, e-file, and the judiciary's new system came in play, much of the work that was being done by the court clerks got shifted back to our staff. We work with them every single Wednesday morning. We get on a call with the judiciary and point out things that are bogging down in the system, whether it's, do we have to file 14 different search warrant requests that are all should be under one search warrant. Some of these things that we point out that are causing hours and hours and hours of work for our administrative staff, we do try to work collaboratively with our partner organizations to resolve them. Sometimes it works, sometimes it doesn't. But the numbers that we've asked for in terms of, we have generally been a pretty stable. Those numbers I read to you earlier, the 135, in terms of the numbers, 27 victim advocates, all of that has been the same. I've been with the department 6 years, and basically that has pretty much been exactly the same. We've been working under those numbers for a really long time. But also, as Defender General Valerio said to you, we are also in a situation, we are in that really tough competitive market for all positions. We are losing positions to other state agencies in Vermont, other state offices where they are fully remote and we are not. the courts are open. And when the courts are open and there's trial, or there's change of plea, or there are arraignments and the judge wants people in the courtroom, then we are in the courtroom. Our offices have been effectively open and staffed for a really, really long time. I think that after the governor shut down in March of 2020, I think we started, I know that Lee Central Office, we staffed with people in here, and most of our offices staffed on rotational basis, but we have been pretty much back full swing for close to a year and a half. We lose people who say to us, well, I don't want to come. Thank you. That's a decent offer under our contract, what we're allowed to offer to people coming in. But they say, so I could work remote all the time, right? And we say, no, you really can't. Part of that is the access to very, very sensitive criminal records. We don't want, that people shouldn't and can't access some of that stuff from home. You don't want people basically taking files home with people's, substantial criminal or medical records. Some of that is really difficult to do. So and then of course we have to be there to support the work that's going on. So, and please do not take this as a criticism, because in no way is it intended as such. But anytime the legislature passes a change in statute or new criminal provision, that has been done, repeatedly without any additional resources and staffing to our offices. So, there's been no commensurate increase in staff despite the fact that there have been multiple changes in Vermont laws. Sealing and expungement may be one of those. It seems like it might be a very simple thing to do, but when you get an order to do that, it might be that only one of 3 charges have been expunged. So in order to make sure that the record is properly expunged, we have to go through to make sure that we are only doing what the court has directed us to do. It is not simply a matter of taking a file, although sealing is pretty much that, but on a lot of the other stuff, it is actually going through and making sure we are doing what the court has directed under the court order. So we are trying very, very hard to ensure that our staff can function and do their jobs and perform efficiently. And I think that we work collaboratively. I was on the phone this week with DOC and the court and Defender General Valerio on transport issues. I mean, we talk all the time as partner organizations. I'm on calls multiple times a week trying to say, how can we do it better, more efficiently? Where are the glitches? Where are the holdups? And I think that is an important role for all of the offices to take. I'm just saying that our staff we're losing people to go to other offices where their caseloads are not 450, or 700 if they're a victim advocate, or admins who are saying, I just can't do this. I'm the only admin in the office. I don't even feel like I can take a vacation. We take calls here. My desk phone rings when the Essex County State's Attorney's Office which has one admin. We have that person transferred down to central office. And, I hope that they don't ask a question that I can't answer. But generally speaking, we try to make sure we get support from the other offices. But yes, we have asked for those positions.
Before you move on, I think we had a question here, Karen.
Yes, thank you for that. Because yes, I think being fully staffed is really important during these times when we're dealing with these caseloads that you mentioned. I'm assuming, and I know it's never good to assume, so that's why I want to check that these positions would go to the places that have the highest caseloads.
Correct. I mean, we would take a look at, I heard, please don't think I'm being impertinent when I call Matt. I've just known him for decades. So but Matt Valerio, I pulled up the case clearance rate from when we're looking at it all the time. So what we would be doing is we would be looking at moving resources around, and we do that every single time. I mean, good budget management says you look at your resources and apply them where they're most needed. So we would be doing that. So we would be looking at the offices that need to be doing more work to clear the backlog. That is our goal too, by the way. Our goal is to make sure that we are not keeping things on the books, not keeping people on the books that really have, that those cases could be moved off. And we talk about that with the DG on a regular basis also. But yes, that is absolutely correct. We would take a look at where we need those resources. Chittenden, for example, has five plus one admin staff person, and they really function very efficiently. But we do have offices where we have one person or two people, and they are struggling mightily, and things are just backing up on their end, on the admin end. So we would be looking at where is the best place to put folks.
Okay, that's helpful. If I can just follow up.
Yeah, go ahead then,
Because
Barbara.
I think that's one of the things that I'm trying to put together with it, because I could see Chittenden also has 5 because the population size is much
Correct.
bigger. But then they're doing the work to maybe not having folks get the charges and having the criminal proceedings. Whereas I feel like if state's attorney, is there an incentive to have a bigger caseload? You're going to get more people. So that means charging more offenses, because then that's going to lead to higher caseloads, and then you're going to get more people there.
Well, I'll tell you this, that Rutland was an area where there was some bog down. And when the new state's attorney came in, one of the things that was said to him is, we need to see some real progress very quickly on your caseload. And as soon as that's done, we will basically free up the positions that potentially could come to you. But we need to first see the progress, and that has happened. The clearance rate there has been very positive, and actually DG Valerio mentioned that on the call this week. So I know that it would seem that way, that you want to look on paper like you have way more, but we actually get the data from the court. So it can't be that an office tells us, oh, we've got X numbers of cases. We actually get the raw data from the courts, and that actually shows us where things are at age-wise, whether the case is criminal, civil, probate. We actually get that. We don't take anybody's word for it. We look at it month to month from the court.
Okay, then it sounds like too that if a state's attorney is diverting a lot of cases because they don't want to see them go through the court system, that's not being calculated in how it's being handled.
Well, there are statistics that talk about diversion and moving cases in that direction. Some of the issue I would say is, don't forget too, that some counties have a lot more resources to send people to than others. And that is something that I think is a bigger conversation at some point, probably for this legislature. I mean, if you have a lot of resources, treatment programs and diversion and Tamarack and all of that you have those options, I think that really is helpful. Not every county, some of the more rural counties don't have as many resources. And that, I think, is a bigger question that I think we would all support, bringing those programs in and supporting those programs too. But they don't necessarily can't move everything in that direction because they don't have those resources.
Barbara has a question as well. Go ahead.
Hi, so I'm a little confused because I think I've heard different things, and I'm now just trying to sort out what is the plan. Earlier you were talking about having one of each of those positions go to each of the 14 offices. And you've also talked about need, which it would be super helpful for us to see the analysis that you did to determine the need to have 14 deputy state attorneys, 14 victim advocates, 14 staff assistants, and what that's based on, because everybody getting 3 of something seems more like it's about like making sure things are fair rather than what the crucial needs are right now. And I was listening to the appropriations presentation that you and John did and heard you say not a deputy attorney for Chittenden County.
What I think I said was at this, well, let me rephrase if I did. What I would say is that as we looked at this, and you're correct, we were looking at starting out with the premise that perhaps everybody could look at getting some support, whether, and so 111, you're right. But in terms of answering what we would look at is, as we do with everything, is where is the real staffing need? Would it be that Essex, for example, needs, I'm just using that because it's a very small county. Would they in fact need another victim advocate? Perhaps not. but they certainly, we would look at and say they definitely need an admin because their public records requests or their archiving and their work with the e-file and serve. Could they use another deputy? We would be looking at those numbers, but potentially. So we would look at everything as it plays out. As you know, and everybody on this committee knows, we get our budget, we get our budget form and we don't really get options in terms of what we get a bottom line number. So at the point that we've not asked for new positions in a really long time, and at the point that we were doing this, it was sort of like, what do you ask for? And what is, and you're saying, what is the plan? I think the plan is to try to get our people out from under 450 caseload cases plus weekends and nights calls. That's on top of their caseload. I'm not saying get them out from that, but that's another pressure on them. And then our victim advocates getting them out from 700 cases. So, and our admin support. So we would look at where positions really are most needed as we get hopefully some positions assigned to us this year.
So, I mean, because as we're looking at competing needs, it's in some cases keeping positions in place that might go away if we don't fund them. So obviously weighing, putting new positions in when public safety may lose their victim advocate coordinator because they don't have enough funds. So I think we're just trying to be really understanding of like what the analysis is and where the needs are so that we can take all these competing needs and try to make a recommendation. So that is really helpful if you do have an analysis that you can share with us like quickly. But the other thing is you mentioned that the transport sheriffs are, we're negotiating their contract now because that's one of the requests we have in Judiciary's budget is what transport deputies are asking for compared to what the governor put in the budget. And I don't know if you can tell us what the hourly rate is that the contract requires for the transport deputies? Or no, actually, you know what? That's not transport, it's security. I'm sorry, I'm confusing two conversations I had about sheriffs. One was with someone on human services. So is that part of a union agreement that we should just know what the dollar amount is so that we're not?
We won't know because we're just going into negotiations for the first time this Thursday evening. So maybe we will know what the cost of the potential contract settlement will be, but hopefully most of that will be covered by Pay Act. I will say that as I've gone through all of the work around the various bills that are pending on the sheriffs, it's interesting insofar as we are getting more and more and more requests for assistance from the state transport deputies. It used to be, they would go to the correctional facilities and bring people to court for their hearings. The transport deputies are now helping out with court security. They're monitoring juveniles when they're being housed, sitting with them or monitoring them. So as opposed to like a social worker sometimes because they don't have a placement for the kid. So we've been approached by child support to help them. Could we deliver, find people and help deliver child support orders? We've been approached by the Department of Labor. We have basically 24 positions, and if we do everything that we're being asked for, we could double that workforce of the state transport deputies. So at some point and I know the courts, DOC has now said we're not doing any civil transports. That's now coming to the sheriffs. That has not been the case up to this point. And the courts are basically saying to you all, we need security through the sheriffs. And the conversation I've had with Terry Corsones is, what does that look like? And where do you find, what level certification are you looking for security? Are you looking for level 2, Vermont Certified Law Enforcement level 2 or level 3? Because if you are, we're competing with every other law enforcement agency in the state. And I think most of you have probably heard about the fact that no one is doing well recruiting law enforcement positions. So I don't know, the staffing on, while we have all these conversations about the sheriffs and the sheriff's department's futures, I want to just say that everyone is looking for the sheriffs to help them. That's my experience. every day I'm getting calls. DOC, Agency of Human Services. So it is an interesting situation to watch.
Thank you.
So if we could back up to make sure that we understand where you are with the different positions in the state's attorney's office. We only have a few more minutes because we have to turn to Jennifer Pullman as well. And we need to wrap this up by 2:30. So you talked a lot about the administrators. I think we certainly understand that. Could you talk a little bit more about victims advocates and deputy state's attorneys positions?
Right. In so far as for the victim advocates, we're just very concerned about the amount of cases that they're trying to manage. So everyone who enters the system, every case that enters the system with a victim should be touched and supported by a victim advocate. Some of that can be very, very simple as to just ensuring that the person is aware of the hearings and what the process is. I mean, a lot of what a victim advocate does is explains the court system and the court process to people and what their rights are under that, and make sure that they are aware of victim compensation provisions. And it depends on obviously the level of the victimization. So our victim advocates are carrying just tremendous amounts of cases. So for example, the Chittenden office has 4 victim advocates. Every other office has 1 or 2. So if you figure that you might have 5 or 6 attorneys in an office, and then you have only a certain number of victim advocates, they're basically picking up all of the victims from those cases. So we really, we're just looking for more assistance to our victim advocates. There has also been work that's been shifted to them over the years in terms of, I think some stuff has come to them over the past few years from corrections. So we are looking at trying to give them some additional support out in the field, even so far as just making sure that we can, as Matt said, trying to make sure we're able to stay in touch with victims. I think he mentioned to you that cases becomes stale after 18 months. You're looking for people. We want to make sure that our victim advocates are able to have enough contact with people that they are able to stay in touch with them and are working with them pretty regularly. In terms of the deputy state's attorneys, I mean, I don't want to be dramatic, but I've heard it said here in this office many, many times, a deputy state's attorney carrying 400 or 450 cases is probably engaging in legal malpractice, because you can't do justice to the work that we have to get done. So we've lost, in the past year, we have lost many attorneys to private practice. Again, I'm not even sure that has been a salary issue, because we have tried very hard to do well by our deputies. We're not quite as high as Matt is, but we're doing better. And I think a lot of that has to do with us working hand in hand with BSEA. The other piece of this is we have lost people to other state agencies. I mean, if you, and no criticism to other offices, but if you can go to the Secretary of State's office and be home, leave your job at 6 o'clock at night, not taking that home and not getting a call from the local police agency, or not going out to a dead body scene or whatever, or you can go over to the Attorney General's office, where they have a very much more reduced caseload than our folks do. Our people, from what we hear is, at 450, we're just over the charts in terms of our caseload.
So a couple questions here, but before I turn to Karen, so do you have data that shows, a trend data as far as the number of cases per attorney? Is that something that's part of your calculation of figuring out or justifying the additional state's attorney's asks?
It hasn't gone down. So in the pandemic with the 7,000, backlog has only made the situation worse. And when Matt and I were talking this week, we both agreed it was sort of like, are we making a dent? We think we're making a dent a little bit, and I think the case clearance rate is somewhat better, but we're not making that number, that 400 to 450 has been with us for years now. So I could probably go back and take a look at the data, the court data from 6-7 years ago and see that, but we're not reducing because we haven't had increased staffing. We're just not reducing the number of cases. And that's just, in our view, too many cases for our staff to be handling.
Okay, Karen.
Yes, so I feel like I got to this before. Because I'm hearing this, how cases are, but I feel like there are tools that are available to deal with cases other than just kind of having them go through the criminal justice system. And I heard you say diversion and some of the other options aren't available, but I know every county is served by a community justice center. Mm-hmm. There are options. And so I feel like finding this balance of, yes, we want to make sure our state's attorneys are well staffed, but are they also doing all the things they can to send cases pre-charge, to refer them to community justice centers, do all that, instead of building up the system to be as robust as possible for the criminal system. So I just think as a committee, looking at restorative justice as well, like how do we hold both?
So I'll be an advocate for our folks and I'll be a cheerleader for them. I think the answer to that is yes. I think that they are taking advantage of all of the available resources in the community. And I think, for example, with I think you've had Tim Luders-Dumont, our legislative attorney, and I think working on this stuff with the referral to the CRGs. Am I getting that terminology correct? Thank you. So, I mean, yes, I do. I want to say that.
Sorry, CJC.
You know what you're talking about. I think I do too, but I just don't know the acronym. But I think that you'll see that we are saying yes to many of those things. And I think we are working so I'm going to say that I do believe our state's attorneys and deputy state's attorneys, I don't think anybody's saying, let me just charge on these things so I can just go from a 400 caseload to a 500 caseload. I mean, there shouldn't be any incentive in doing that. There's no extra reward or extra money because you carry more cases than the person sitting next to you or the office down the road.
Great. I really appreciate your testimony, and I do understand that there's still additional work that's being done, that you're honing that request, and if Trevor reaches out to us again to provide some further input on that, we may have to touch base with you again, but I appreciate your time today.
Thank you, and I appreciate yours also. Thank you very much. John asked me please to apologize. John Campbell, he has some sort of a viral thing that's mimicking mumps, and he said he really couldn't get on camera and he can't talk. So he asked me to apologize that he was not here with me today, but we actually told him he could not come to the office and give us whatever he has. So thank you.
All right, thank you very much.
Thank you.
So we're going to go to Jennifer Pullman now. We have about 10 minutes. Hopefully that's good, and otherwise we can talk a little more offline. So we have Michelle coming up at 2:30 to give us a walkthrough of
Sure, I'll try and not speak quickly and just speak efficiently, if that helps. I know that I have 6 friends on the committee who've been through the center's issues before. So would it be helpful, Mr. Chair, just to speak to a 2-minute overview of what we do and then get right into our ask? Our ask is going to be really simple.
Sure.
We'll end the day on a good note.
No, that sounds good.
Good afternoon. For the record, Jennifer Pullman with the Vermont Center for Crime Victim Services, and thank you for allowing me to testify virtually. I'm juggling kids at home with vacation and being a mom and still working, so I appreciate that. And I know that Penina has put up documents for you to review as well, and I'll speak specifically to 2 that I believe Penina in her kindness did provide hard copies of. As far as the center itself, and I know that I've had the pleasure of meeting with you and speaking with you, just a reminder that we are this weird quasi-state agency established under 13 VSA 5361. We have many responsibilities, but for your purposes, as far as direct services, mainly it's just to understand that we administer the Victims' Compensation Program, the restitution unit, and we can come in and testify on that in future bills that I see coming down the pike. As far as the pieces that are most relevant, we also do provide, as a state agency, the pass through for state dollars and for federal dollars. for programs that are in your communities throughout. With respect to how that looks, we do receive, and there is a sheet that you have that has a nice pie chart that shows how very little we receive in terms of general fund dollars. That $1,400,000 basically is a straight pass-through in general fund dollars that supports child advocacy centers, supervised visitation programs, some specialized prosecutors, as well as network programs. There has been no increase in those general fund dollars to increase to our base. So that is a straight pass-through. We are the only state agency that does not receive any general fund dollars. So all of our expenses, all of our employees are funded through other avenues, and I'll speak to those pieces. With respect to state special funds, as you can see, there's two other primary ways we have get our funding. One is through special funds. We receive those through fees and fines on traffic tickets and on criminal convictions. Those have been in a steady decline. We've lost pretty much about a 47% decline, and it's not a COVID decline. This was actually recognized back in 2012 when the legislature asked for a report. And in 2013, the report came back saying that for the center to rely on special funds, it was not sustainable. There were no changes made at that time, and we've continued to rely on special funds to support these important programs, both through the compensation special fund, the DVSB special fund that supports network programs throughout the state, and also supports the restitution unit. So this is not something new relative to COVID. And in thinking about it, I thought about a question that Representative Burdick asked me on my first day in this session, which is, when we make changes, does that impact what you receive in terms of funding? And it does, and that's something we struggle with because we support the reform efforts, but certainly there is that ripple effect in terms of each change that you make sometimes does impact what we are able to do and what funding is available to us. And if you look at the JFO report, that's actually, I didn't ask for that to be printed, but it is on your page. On the JFO report, on page 4, they do outline the fact that there have been many changes with respect to the ability to waive fees and fines, with respect to the ability to expunge cases that we're not going to see a change in the special funds. And despite the fact that I personally believe that I will have contributed to the special fund based on a traffic ticket that I received, there is a decline in that, and that's not going to change. That's due to availability of law enforcement officers, but as well as the just a change in terms of how we use that resource and what's most effective. So we're looking at that, and then we come to our federal funds, and we have 267 different grants that we administer to 67 subgrantees in the state through our federal funds. And those are really volatile, unpredictable. Over the past several years, we've lost about $9 million in VOCA funds. That's the Victim of Crime Act dollars. That pretty much is the primary piece that provides funding for our programs. So it's volatile, to say the least. There's been some fixes legislatively, so we hope it will stabilize. But at this point in time, we are looking at a high just a few years ago of about $6 million coming into the state, and now we are hopeful that we rebound from about $2.5 million to $3 million this year. So thankfully, we've been really thoughtful about when we did get additional increases in terms of saving those for rainy days, and we have not had to make any cuts. We're also thankful to this body for providing one-time ARPA funds that were able to keep doors open. So as far as our asks, and again, we get back to the point of, how are we funding core services? How are we funding what we see, and I think what the state sees as incredibly important? And for the most part, we're doing this through special funds and general funds. And we know that neither is predictable, and special funds are not going to come back. So our ask was pretty minimal, and it's pretty simple. And fortunately, the governor did recommend put in his budget most of our requests. Our first request, and you'll see that in the JFO report with respect to recommendation number 1, was that the surcharge that currently exists in 13 BSA 7282 is which provides for a $47 surcharge on criminal convictions. $29.75 currently goes to the Victims Compensation Fund and $10 to the DV SV Special Fund, and $7.25 goes to the General Fund. That was projected about a year ago by JFO to generate maybe $300,000 to $400,000 for the General Fund. Currently, I think it's more conservative to say it's about $250,000 to $300,000. They recommend from the governor, our request, and the governor did support this, it's in his budget, is that that surcharge, that $725, be split between the DV-SV fund and the compensation special fund. It's really important to note that despite the efforts of this body, that the DV-SV fund is still on target to be about $300,000 short this year. So we can begin to think about acting on some of the recommendations that were in the JFO report. That would be incredibly significant. And again, that is in the governor's recommend. As far as, and I know that Representative Rachelson has also introduced a bill, H303, that will produce language that would be very helpful to the Appropriations Committee to be considered. The second is the DV trainer. The domestic violence trainer is established through statute to be placed within the Criminal Justice Council under 20 VSA 2365. That's also in the governor's recommend. Currently, under statute, we are obligated to provide funding for that position out of the DV-SV fund for the state position, and that will amounts to over $61,000 out of a failing fund. And again, our position is it's a state position. It should be state funded, and it's a position that we can't control the expense for because that position continues to get COLAs and steps even while network programs and other subgrantees are flat funded. Finally, and I apologize, I'm speaking fast. I'm mindful of the time on my computer. We had asked for support for the Vermont State Police Victim Services positions. There are 2 positions within the state police that support victim services. One is a victim services specialist. One is the victim services director. They're both funded through grants. These positions are incredible. They go to every single death scene, whether it's a homicide or not, and respond to all major crimes. They work 24/7. So when the police get a call, they are out on the road and they are there to support the troopers, to support the victims, and then to work these cases before they get to a prosecutor's office. The amount of support that they have within state police, within the victims that we've had connections with, and the amount of support that they do in terms of preparing that case, getting compensation in victims' hands immediately cannot be described. It's so invaluable, and it's really a model for the rest of the country. One position, which was Amy Fars, the victim services specialist, was funded through a discretionary grant, which was to end on June 30th of this year. That position was picked up in the governor's recommend, and we are very grateful for that because there was no way that there could be additional funding for that position. The other position, which is held by Kate Brayton, the victim services director, is funded through VOCA. That was not picked up. Commissioner Morrison is extremely supportive of both positions, but by the time that this conversation happened, she'd already submitted her budget. So she was like, if you can do this, you'll be our hero. Otherwise, we're back at it next year. So I think what we're hoping for, and this is our only ask above the recommend, is that the victim services director position in the amount of $137,000 and $137,100 is picked up in the general funds to secure that program. The services they provide, talk about efficiencies, talk about backlog. They're right there for the sexual assault, the serious domestic violence, every death. They are right there working with victims. Our only ask over the recommend is that this position get picked up. $137,000. That's all we're asking over the recommend. So I know that I'm over my time, and I had a bunch of other comments I wanted to make, but I want to pause, Mr. Chair, and see if you want me to continue or if there's space.
Tom has a question first, and we're waiting for Michelle to show up, so go ahead, Tom.
Mine's quick. I'm just trying to wrap my arms around something. You said you have people that work with the state police and public safety department. Are they employees of public safety? Are they contractors? Are they employees of crime victim services? Are you a state agency? What's happening? I'm just trying to figure it out.
This is very odd, and Appropriations was trying to struggle with this themselves because we're coming in asking for positions for another agency. They are state employees of the state police, but they are grant funded. So they receive all the benefits, all those other pieces, but the funding actually comes from a grant. And our concern is that the grant is volatile, and it feels that this is a really important service that they're already state employees. It should be built into their budget. So we have really nothing to gain from this. We just feel that the program is so solid and is so important that we're in a position that Commissioner Morrison isn't quite this year in terms of saying, please fund this. One position's already picked up. It makes sense to pick up the other one. Is that fair?
I think so, yeah. Thank you.
All right,
It's very
appreciate
odd.
it. So if there are other comments that you could, shoot us or shoot particularly Barbara an email. Are you good with what you need, or you can work offline?
Yeah, I can certainly work offline. There are a couple of, there are a couple of things that I would still like to ask, but I can ask them offline as well and
Incorporate them into.
yeah.
Yeah, so we kind of are a little bit tight on time, so really appreciate your testimony. Here's what we're going to do. We have one fewer witness on 288, so we have a little more time. So we're going to start that at like 3 o'clock. But right now we're going to get a walkthrough, and if you have the S on H40, whatever the number is, we're going to get a walkthrough. This is what we talked about on Friday. We'll take a look and we'll see if after we have the walkthrough and have a discussion if we are ready to go or not. So here's an version of what I had. So we had a couple changes from earlier last week that Michelle has now incorporated into this. But yeah, just real quickly, we have somebody who's going to be talking about the ISO ratings, Stephen Clark, and he's unable to make it until Friday afternoon, so that's why it's freed up a little bit of time, so we can proceed with page 40 first, and then we'll get to communicate. With that, over to you, Michelle.
Hello, good afternoon. For the record, Michelle Childs, Office of Legislative Counsel. Can you guys hear me okay?
Yes.
Right. I'm headed to Florence on Saturday and I don't want anything messing this up. So I'm worried.
Florence, Italy, or
Yeah.
All right.
North Carolina, no.
Well, there's Florence, Vermont, down by Pittsburgh. She's a very lovely place.
So let me know if you have any issues with my projection. So we're looking. So we're looking at draft 4.1 of a strike all committee amendment to H40. So section 1, just your definition sections in the chapter that this applies. I know there was some debate about where this new civil action should be located. And I know some of the witnesses, I think Judge Zone had said, oh, it should be in Title 12 because it's a civil action. There's no longer a criminal penalty there. And I spent a little time looking at it. My opinion is Title 12 is a hot mess, and there's really no great location to put this in. I don't think it belongs in Chapter 178, which is the orders against stalking and sexual assault, because it's not related to those protection orders. We do have a number of statutes in Title 13 that do allow for civil actions. And so it made sense to me to keep this in Chapter 72, which is the sexual assault chapter. because of the definitions that we're using. And so you see the definitions in section 1. We talk about sexual act. We also talk about consent. And those are critical definitions to understanding the language in the new statute that you put. So that's why I chose to go with 13. Martin graciously acquiesced after I made my pitch.
That made sense to me.
So I just wanted to let you know kind of where we're at with that. So you see the definitions in section 1. The only amendment that is in section 1 is just striking that language, but not limited to, because you know that we have that provision in Title 1 about that when you say including, it means including but not limited to. So we strike it when we see it in there in old language. But I kind of did that so that folks who are looking at it on the floor will be able to see those definitions. And if I didn't amend that section, I couldn't put it in there. So that's why it's there. So section 2 is your new provision with regard to the civil action. You'll see no person shall engage in a sexual act, and then going back to the definition section, with another person when consent to the sexual act. Again, you have a definition of consent in the definition section for chapter 72. Is made with the explicit understanding that a condom would be used and intentionally and without consent remove or tamper with the condom prior to or during the sexual act in a manner likely to render it ineffective for its common purpose. So I can't remember the last version y'all saw, but I've changed the language around consent and the agreement. So we're using existing defined terms. This is obviously only applying to condoms. The bill as introduced was much broader.
I think the only thing that changed since we last looked at this and went through it is adding prior to on line 7.
That's it? Okay.
Yeah.
I can't, there's so many drafts going these days. I can't remember.
And the statute.
But yeah.
And the statute of limitations.
Yeah, and the statute.
Right. And so subsection B is just establishing the civil action. And then subsection C is directing it that an action under subsection B shall be subject to the statute of limitations. And then I'm referencing Title 12, and that's the provision for civil actions of a 6-year statute of limitations. Martin brought up a good point, which was before he had said just add something in there that says that it's 6 years instead of 3 for personal injury. But we want to make sure that the minority tolling provision that is also in the chapter for the civil actions in Title 12 applies, which it does if it's in there. So we want to refer back to the Title 12 provision. And so that's why it says that.
And I will say this is one of the good things that came from me reading all the dram shop cases over the weekend, because that's where I kind of picked up on this fact that we needed to anchor this in that title.
Right. And then I also just wanted to note that we have a new title. There.
Ken.
Are you talking about that from the 3 years to the 6 years? Were you still on that when you were?
Yes, 6 years.
But somebody said they really liked the 3 years. Was it Zone? Who was it because I wrote that down. Not comfortable with the 6 years.
I think that we had testimony from some of the folks, most of the folks actually said 6 years as well. Ella.
Yeah, my notes just related to that were that either 3 or 6 were sort of typical. 3 was typical for personal injuries where you would know that you had been injured right away, and 6 was for civil damages, which was broader, and there was some discussion about the pros and cons for both. But I think that what I heard is that the emotional challenge in this kind of experience is very different than a car accident and having a whiplash. The emotional process to get through to even realize that there were damages can take quite a long time. And that's where we were leaning. And that's why there was conversation about 6 years instead of 3.
Thank you.
Sure.
Yes, and I think I also had a note too of the 6, especially because the criminal piece was removed, that allows a longer period of time for that as well.
Right, we wanted a shorter period of time if it was criminal offense, but since it's civil, that was an additional reason why we went to 6. Any other questions for Michelle? And if not questions, we can have some discussion of where folks are with this, if we're ready to vote on this particular bill. I don't know that there's much more to hear from, frankly. And, I think we had most of this language all through last week, except for the statute of limitations and that prior to wording, so.
I don't mean to be difficult here,
No,
but
no.
you're just giving us a new draft and you're asking us to just go and talk right now and then vote now?
You can look at it, we can postpone the vote for after we hear witnesses on 288. I mean, if we were changing anything that we didn't fully discuss last week, then yes, but this is language that incorporates the input that we got last week. And this was the directive as far as what we wanted changed on here. So I mean, if you're uncomfortable, we can wait and we can postpone until later. And if there's still that discomfort, we can talk about postponing it. But main thing is I wanted to get this out of the way this week. Because if we don't vote it out today, it's something that's hanging out over not that I think that's a huge deal, frankly, but we have a pretty busy schedule the next couple of days. So even fitting this in tomorrow, but yeah, we'll take a break until 3, and that's when we'll start on 288. And we have a couple witnesses. Yeah, but before we do that, Karen.
I'll just share, I have another commitment at 3:30, so I don't know, like happy to pause on it as well, but.
Well, we can take a break till 3, and then we'll decide whether we're gonna vote on this at 3 o'clock.
Don't you have a commissioner out there waiting to testify?
We have a commissioner, I think, online, right?
Yeah.
Yeah, they're gonna be online.
Right outside the door.
Oh, we have
Are
somebody
you
else?
talking about Wendy? Commissioner Knight? She's supposed to be here at 2:30.
Oh, okay.
Yeah, but we've been in touch with them to say, did you tell them 2:15 or 3:15? Okay, yeah, so they're gonna be at 3:15, so we have a little bit of time. We'll get back at 3.